Hi, it's Marc from CASE-MCQ, the Center for Access to Services in English, Mauricie, Centre du Québec. Don't forget to visit our website, CASE-MCQ.com, and don't forget to click and like and follow us on Facebook to be up to date with all the different activities for the English-speaking community of the Mauricie, Centre du Québec region. I'm happily married, and one of my friends said, hey, in this modern day and age, you don't need to be married, blah, blah, blah. You can just stay common law partners and this and that. I wanted to have the right info, so I pulled a couple of strings and got a personal meeting one-to-one with Maître Rick Goldman from Éducaloi. Let's meet him now. Wow, what an honor to be with Maître Rick Goldman, a lawyer with Éducaloi. Hi, Rick. Thanks for taking time for me out of your busy schedule. I've seen you on a Éducaloi webinar. Can you clarify for everyone in the internet world, what exactly is Éducaloi?
Okay, well, first of all, Marc, the honor is mine to be in on this interview with you. And thank you to any of you, all of you, hopefully all and not any, who are joining us to watch this. First things first, what is Éducaloi? Well, Éducaloi is a nonprofit organization with the mission of explaining to Quebecers their rights and their obligations in an understandable language. And we have various means of doing this. Our principal resource is our website, educaloi.qc.ca. And there we have more than 1,000 different types of content, bilingual, English and French, everything from quite short articles about new developments in the law. Sometimes you see something in the news, like medical aid in dying or new restrictions for COVID and this type of thing. So we try to update people as quickly as possible with short updates. Everything from that to more classic articles, let's say 1,000 words on your rights as a tenant when you get a rent increase, for example. That would be typical everyday situation, or family law, which is something we're going to be talking about today, right up to very detailed guides. Let's say a guide on wills. We have, for example, 28-page guide on different types of wills or power of attorney, things like that, and a variety of other tools, generally shorter, but some slightly longer videos. We have a whole array of tools for classroom education. So we have a whole part of Éducaloi. You can hear Educa and Loi, Educa for education, because a very important part of the mission is bringing law into the classroom, mainly at the high school level and adult education level, in order to give people an idea of their rights in different areas, and also even give young people an idea of possible legal careers. So all of this can be accessed with the starting point of our website, educaloi.qc.ca. One more thing, in addition to going to our website, there's different ways to follow us. Notably Facebook. We have a very active Facebook page, and interactive. We have Facebook live broadcasts from time to time, kind of a little bit similar to what we're doing today. We have Instagram, and we have Twitter. So different ways to follow us, so you get automatic updates about things.
I'm married right now for 20-something years. And before getting married, we were juggling with the idea of getting married or not. Was it important or not? So let's dig into the subject. What does common law mean in Quebec?
First of all, congratulations on your more than 20 years of marriage. I'm proud to say that my wife and I will this year celebrate 30 years of marriage.
Wow.
So we're both veterans. We're both veterans of marriage. Going to the question of the day, what does common law mean in Quebec? One of the challenges is that there's, well, you could say there's a simple answer and a more complicated answer, but Éducaloi, our job is to try to make things as understandable as possible. So to put in the most understandable terms, it's when two people, could be different sex, could be same sex, live together like in a relationship, in a committed relationship, similar to marriage. And that is a kind of circular term, because we're saying, well, what is what is common law? And we have to refer back to something that's not common law, but that's the best we can do. There are times when people dispute for one reason or another. Sometimes they say they're in a common law relationship, because it could bring them an advantage, and other times they say they're not, because it could actually be a disadvantage in some situations. So that is the best we can do in terms of a definition. It's not defined any more clearly in any law. And here's another challenge, and it really touches on our topic of today. There's no, in different laws, there's different criteria for when you are in a common law relationship. And I'll give just a couple of examples so maybe it's a little clearer. In the housing area, if two people live together as common law, by the way, I should also make a parenthesis, the more official term in Quebec is de facto relationship. But even that is not really an official, that is not really the official term, because if you go, for example, on the Quebec government website, Justice Quebec, you will see both terms used, common law, or the Board of Notaries website, you will see common law relationship and you will see de facto relationship, just so you know they're the same thing, okay? So going back to the challenge, there's no one uniform set of criteria. I gave the very general thing: two people, same sex or different sex, are living together in a committed relationship, but different laws add some criteria to that. So for example, in housing, if a couple is living together, common law, and one leaves, the one who's on the lease leaves, then the other could take over if they have been living together for 6 months. So housing, it's a 6-month cohabitation criteria. Immigration, you can sponsor a spouse if you have been living together for 1 year. Quebec pension plan, you may be able to receive a death benefit from if your common law spouse sadly passes away, if you've been together 3 years. So it's very, very challenging because there's no one fixed set of criteria that applies across all areas of law. And the most kind of challenging thing, which is really the topic of today, is that in family law, there isn't even a recognition of common law spouses, in the sense that, as in this is what we're talking about today, common law spouses essentially have none of the rights of married spouses. So we're going to look in more detail what that means, different areas of rights. But there's, unlike say housing, where you live together 6 months and you acquire certain rights, like to take over the lease if your partner leaves. In family law, no matter how long you live together, you don't acquire the rights of a married couple, and we're going to look at some of those rights, I think, one by one a bit later on.
You said after 6 months of living together, they can take over the lease. Is it a right or an obligation?
Yes, it is a right and not an obligation. So, for example, I've done quite a bit of housing law over the years, and if, let's use an exact example. So people have been living together a year or two. The one who has the lease moves out. So the one who's remaining there has no lease. That person, it kind of has an interesting situation, because they have the right to take over the lease, but no obligation. So they could actually hang around a month or two. They have no legal obligations whatsoever until the landlord finally cancels the lease for non-payment of rent, because they're not responsible for paying the rent. It's the one who's on the lease. So they have a kind of good situation for a month or two where they can decide, do I want to stay or not?
I'm looking through a lease here. I remember there's a place that says that they have to declare if it's a
family residence.
Yes.
But that really just applies for married couples. If it's declared as a family residence, then one cannot say sublease or transfer without the other's permission.
I had specific questions, so I wrote them down.
Okay.
Two people fall in love, move in together, then decide, should we get married or just live together? Are there many differences between a couple who's married and a couple just living together in common law in Quebec? And if so, what are some of the differences in rules?
So now we're really getting to the heart of the matter, and the fact that living in common law does not create the same rules and the same protections as getting legally married. So some of the main, you could say, deficiencies in terms of protecting the more vulnerable partner, maybe the partner who has less economic assets and so on, is that there's no what's called family patrimony created. So we have to take a step back if we're comparing to marriage to discuss a tiny bit what happens when people get married. When people get married in Quebec now, there's something called the family patrimony created.
You mean they accumulate together?
That's right. That's exactly it. They accumulate the most important assets together. What are these most important assets? They're the principal residence, if they own a house, a secondary residence, if they're fortunate enough to have that, any vehicles that they may own, and very importantly, a pension plan, so RSPs, and also contributions to a pension plan like the Quebec pension plan. So all of this is created when a married couple gets married in Quebec now, and should they down the road get divorced, there is a split of these assets. Now, it can get more complicated than that. I'll give you just a little parenthesis. If one of them already owns a home before they get married, then it's the increase in the value of the home, not a 50-50 split. It's the increase during the time of the marriage. But let's just say a couple that young couple that starts out with nothing and over 20, 30 years accumulates these things that we talked about, a home, a pension plan, one or two vehicles, and so on. And they started out with nothing and accumulated all this during the marriage. This will be split 50-50. So you could see how if one is going out and earning a very good salary, and there's a division of work where one is staying home, taking care of the home, maybe taking care of the children, but not earning a salary in the work job market, that person will be quite well protected by this family patrimony regime.
Because they're building as a team together. So
that's right. That is the exact concept is they are contributing as a team, and they should share equally, whether one is out in the job market with a paycheck every week or one is dealing with the multifaceted and seemingly never-ending work of running a home and raising children. So that's a very important protection. That protection does not exist for common law couples. So a common law couple, it's very hard to picture it really, but if we look at that same situation that we just talked about, a couple in their 20s moves in together, has a couple of kids, one goes out, earns a lot of money, contributes a lot to their RSP, the Quebec pension plan, and so on. The other stays home, works just as hard, maybe more hours, taking care of their responsibilities. 25 years later, they split. Legally, it's as though they were roommates. It's very hard to believe because, you might have a roommate when you're in university for a year or two, and even that's kind of messy to decide, well, who bought the stereo and who bought the coffee table. But imagine that after 25 years of raising a family together. So that's one huge lack of protection. Now, another one is the obligation of support. So let's use our married example first. So the married example, they sadly split up after 25 years. The kids are not even adults yet, or some of them are not adults. Some are in school. Some have to still need care. And one has been out of the job market for 20, 25 years. In a married couple, there's an obligation of support as long as they're married. So if takes a couple of years to get divorced, there's a totally clear obligation of support. And even after the divorce, that's much more flexible. The judge may decide that to promote independence, the judge will grant, let's say, 5 years or 3 years of support to allow the other partner to go back to school or something like that. But there is typically some support where there's a very unequal situation during the marriage economically. For common law spouses, there's absolutely no obligation of support. So using that same example, one has been out of the job market for 20 or 25 years. They split up. There's no obligation of support. So these are very, very important differences in rules and protections. And one of the scary things is that when there's been over the years a couple of opinion polls, one by the Board of Notaries, and it showed that the majority of people don't understand this. The majority of people believe that after some period of time living together, they acquire some rights similar to a married couple, and it's just not the case.
I have some friends that are same-sex partners. It's exactly the same conditions for them, right?
It's exactly the same for legally married, exactly the same for common law. It's the system is blind now in terms of gender. Everybody's on an equal footing.
Listening to what you just said, kind of makes you think, whoa, being just common law partners is like living with. Are there any benefits to living in common law in Quebec compared to being married?
Well, I mean, it depends how you're looking at it. If you're the one with all the assets, there's a big advantage because you can walk away. Éducaloi, our mission is to inform people who are at more of a disadvantage in terms of their knowing their rights or being able to assert their rights. So we're more concerned about people who might be disadvantaged in this situation and in most situations, because the powerful always have the resources to protect themselves. So from the perspective of the person who is in a weaker economic situation, there's no advantage. I could open a tiny parenthesis here. There's only one law I know of in Quebec where there's a kind of advantage to, no, even that's not true. In the area of welfare law, I'm just going to open a parenthesis here. If you're legally married, then from the first day that you're living together, it's the income of both spouses that's taken into account. Whereas if you're common law, for the first year, your spouse's income aren't taken into account. So it's a very limited advantage. In other words, if you're living common law, you're on welfare, you're living common law with someone with an income for the first year, you'll be able to keep your welfare. That's a pretty small advantage. You have to go off welfare after that because your spouse's income will be taken into account. And that's the only one I know where the economically disadvantaged person would in some small way benefit from being in common law as opposed to being legally married.
We're talking about breaking up. Now that makes me think about children. What happens with the children, with the rights, and all that mix up when there's a split? Let's say if you're married or if you're in common law.
Well, the good thing there is children are in no way penalized for regarding the status of the civil status of their parents. It has zero effect whether the parents were legally married or living in common law. Issues of custody, support payments, visiting rights, parental authority are all decided if they must be decided by a court, if they're not worked out on a friendly basis by the couple. If the matter goes to court, all these issues, once again, custody, visiting rights, child support payments. Sorry, I want to add child and underline it because we pointed out before that there are no spousal support payments for common law. Child support payments, all these things are decided based on the best interests of the child. So it will not at all be taken into account. It's just not a factor if this comes up for a decision before a judge, whether the couple chose to be legally married or chose to live in a common law situation.
Maître Rick, I'm thinking that with marriage, there's protection because, you know, you do the paperwork also. You lock in legally that you're married with the other person. Is there something that someone in common law can do? Is there certain paperwork that they can do to protect themselves?
Yes, there is. There's something called either a de facto relationship contract. It doesn't have any official name, or a common law cohabitation contract. And there's quite a bit of information both at the Chambre des Notaires, the Board of Notaries website about this, and Justice Quebec website. And the odd thing is when you look at some suggestions of what to put in, it's as though you're getting married without getting married. As a matter of fact, it's much more paperwork because you have to write out in detail. You know, we talked about these things, family patrimony and support payments in case of divorce. These are automatic. Like if you get married, all of these things, all of these rights come to you automatically. If you want to have those rights, create those rights within the couple and your common law, you have to write each one out by hand. Like we will get a split of the family patrimony. One will pledge to provide support to the other and put the conditions under which they might give support. It becomes, I would say, I don't know, much more, maybe 10 times more complicated in terms of paperwork than just getting married, where all these laws are in our civil code and other places. And so given that most people who make the choice to not get married, to live in common law, probably in part do it because they don't want things to be too official. They don't want a lot of paperwork. It's hard to imagine why somebody in that situation will want to spend much more time on paperwork than would be involved in getting married. And as a result, what I hear from colleagues who do a lot of family law is almost nobody does it. Like there's some good information on it. As I mentioned, the Justice Quebec website, and all you have to do is Google common law cohabitation contract or de facto cohabitation contract. It'll come up. There's a lot of good information on it, but it's not an obvious thing for people who are kind of who don't like the idea of paperwork, who don't like things too official, and so it hasn't really caught on. With that said, it is possible, and there's even a number of court decisions now that show that the courts respect these agreements. They treat them just as seriously as the same obligations of a married couple. So for some people, because these cases are going to court, there are some of them, for some people, this has proven to be an option, and it could be something to think about. So it exists out there as an option. Now, there are some other things that are not specific to common law, but are types of protections. They apply also in a marriage, but it doesn't have to do with the breakup of the couple. So two that come to mind are the protection mandate. So this is something that is not automatic to a married couple either. Is should one spouse become incapable of making decisions, it will allow the other spouse, it doesn't have to be a spouse, it could be the brother, it could be the adult child, whoever, to make certain important decisions, such as where will the person be housed, make medical decisions for them, and so on.
In French, I already read that. That's the mandat en cas d'inaptitude. Le mandat en cas d'inaptitude.
Right, also called mandat de protection. That work, both are used. So that's something that is an important protection. Again, not specific to common law for any couple, even married. It doesn't come automatically with marriage. Another one is the will. Now here, that's actually a third thing that I should have mentioned when I said, you asked me what are some of the differences in rules. That's an important one I should have flagged, but anyway, we're coming to it. We're coming to it now. If a common law, if a married couple, a couple is married and one passes away without a will, okay, the legal spouse has the right to inherit something automatically. Depending on the composition of the family, if there's children, there's not children, it may be more or less. A spouse will have to share it with the children, for example, but the spouse will always have the right to inherit something.
The married spouse.
A married spouse.
Okay.
I'm sorry, I have to keep saying that. A married spouse. A common law spouse, there's no right to inherit. You could be living with somebody 30 years and you will not have the right. And if they don't have a will, you will inherit zero.
Wow.
So an important protection, and this applies to married couples, but married spouses do have some protection. An important protection is the will, to make sure that should a person pass away, their spouse will get what they would want, their common law spouse would get what they want them to get. Those are three areas of protection. Well, 3-4 areas. We could talk about the common law cohabitation contract, then the protection mandate, and also the will. Is
there examples of this somewhere?
I'm going to plug Éducaloi again. Aside from that, so for cohabitation contract, the best source, because they give very specific example of content that you can put in, are the Board of Notaries website, Chambre des Notaires, and Justice Quebec. For the other things, wills and protection mandates, I'm very happy with the content that Éducaloi has to offer. So if you go to our website or even just Google it, it works. It's even faster to put Éducaloi protection mandate, Éducaloi wills. You will get to all our content on wills. And in this area, we have very detailed content, starting with relatively short articles, even some short videos, to 28-page guides with give examples of the different things you could put in, formulations, and so on.
People think about getting married, or they understand, let's say, through this video that yes, for legal reasons it would be important to get married, they don't have to go through the whole shebang of having the reception and the people and this and that. If they want, they can just go to the
Palais
to
de
the
Justice.
Palais de Justice and just get the paperwork done, right?
No,
The contract.
absolutely. As much as many of our family members appreciate a nice big reception, or at least did 30 years ago, or 20 years ago, as the case may be, that's not a legal requirement. It may be a social requirement or close to it, but it's not a legal requirement. As long as your marriage is legally recognized, which means for many people, the simplest option will be to go to the local courthouse. So that's there's a civil marriage office, and actually the waiting time can differ quite a bit from time to time. I know people have mentioned to me sometimes at different points in time. I don't know today what it is. It could have been 3 months at Montreal courthouse, but let's say 2 weeks in Longueuil, something like that. So you can, if you're in a rush for whatever reason, you can shop around for what the quickest waiting period is. Quebec has become much more flexible in terms of who can officiate marriage as well. Most religious denominations can have their official accredited. So if you are affiliated or in some way, you can check with your religious congregation. And then there are even provisions, I'm not really an expert on this, but provisions for an individual to just get permission to carry out one marriage. So it could be a good friend of yours, a family member, or something like that.
They can do it 3 times in their lifetime. I looked it up. And
Okay.
your friend or family, there has to be a certain length though with the person that's getting married, and they can do that 3 times in their lifetime without being tied to a religious congregation or organization.
Okay,
So if there's
so
something really special, but there is certain rules and regulations that they do need to follow though.
all right. So you're more up on that than I am. Thank you for sharing.
And I do think that being married, if all the paperwork, if all the contracts are in the right order, it's also another way of saying if you want peace, prepare for war. Meaning, if everything's okay, I think you won't have any problems because you already know what's going to happen if ever you split up. So I think you don't get more tensions because of the splitting up. I think it's a better way of trying to fix things instead of going straight and getting anxious and oh we're going to split up, or to try to get as much stuff as you can before the boats.
Yes, and I think the point is well taken. The good thing about marriage is all the things we talked about, all the protections, the family patrimony, the support if you need it, the right to inherit something, all of these come without having to do anything. So the family that goes to the courthouse may never have to think about the family patrimony, support payments, inheritance, but they have these protections automatically. And being myself, like you, Mark, legally married, I haven't had to, my wife and I haven't had to think about it, but it seems to me that if a young couple who is just starting out in life with only dreams ahead has to sit down and go through all these things, like what happens if we split up? What happens if one dies? What happens if you accumulate more property than I do? That could cause some tension. I mean, I don't see anything pleasant about that.
On television, you see these stars breaking up, and they always say, "Oh, they didn't have a prenup. They didn't have a prenup." Is that something that exists only in the States, or is there something that exists also here in Quebec? Is it something that you can do before a marriage, or is it only for common law partners? How does that work?
So it exists in a form in Quebec, but much more limited than the ones we see, on in the States where somebody is only getting 20 million because because she was married to Jeff Bezos and he's, worth as 50 billion, whatever. In Quebec, we talked earlier about all the different protections that come with marriage, the family patrimony, the right to inherit, the right to support payments. This is, you could say, baked into Quebec family law. You cannot contract out of it. If you were to sign an agreement, a couple were to sign an agreement saying, I renounce to the family patrimony, I renounce to support payments, it would have no legal value. These are what are called public order provisions that no one can contract out of. So because of that, there's very little scope for what we think of as a prenuptial agreement when we see it on TV. Now, there still does exist something called a marriage contract, which is in Quebec, which is the closest equivalent of a prenuptial agreement. But because it can't tamper with these very fundamental protections that we talked about, it has a limited scope. It's limited more or less. And it's kind of archaic. It's because I remember like 30 years ago, before a lot of these protections, like the family patrimony even existed, it had much more of a role. For example, it sounds pretty archaic. A husband would promise in the marriage contract to give a gift of $15,000 of furniture and $10,000 of cash to his wife during the marriage. That would be the kind of thing that you would find in a marriage contract. Because there was not necessarily an equal split anywhere. You could have at that time, it's kind of ancient history, but you could have at that time a marriage contract that said, we are in complete separation of property. So whatever I have before the marriage will stay with mine. Whatever I accumulate during the marriage will be mine. And if we split, that's it. Therefore, as the husband who's going out and working, we're talking 34 years ago, it's kind of stereotypical thing. I promise to give you 15,000 in furniture and 10,000 in cash during the marriage. Okay. Now that everything is essentially equal, if you're legally married, there's not really any reason for this. Not to mention that in the workplace, you know, we're pretty close to equality in terms of women's participation in the workplace as well. So there's very little scope for that. But it can exist if you want to have it with this type of thing, where essentially it's just, you can also create a gift upon death, but I mean, you can do it in a marriage contract, but you'd normally do it in a will. It's like the logical place. So there's very limited scope for it. So the type of prenuptial we see on TV, on American TV, almost doesn't, I mean, there's really no scope for it in Quebec.
Thank you so much, Maître Rick. And if people have other legal questions, they can go to the website, éducaloi.ca. It's in English and French. And now the question is, are you going to get married or not? Let's see that. Thank you so much, Maître Rick. Have a super day.
You too. Always a pleasure, Marc.